Thank you very much. Caribbean Court of Justice, appellate jurisdiction, on appeal from the Court of Appeal of Belize, judgment delivery in CCJ appeal BZCV number 3 of 2022 between Caye International Bank Ltd and Rosemore International Corporation. The members of the delivery panel are Mr. Justice Witt, presiding judge.
Good afternoon, counsel.
Mr. Justice Anderson.
Good afternoon, counsel.
Madam Justice Rajnath-Lee.
Good afternoon, everyone.
Mr. Justice Barrow.
Good afternoon, counsel.
And Mr. Justice Burgess.
Good afternoon, counsel.
May we have the appearances, please? Thank you.
Good afternoon, Your Honors. I am Sheena Pitts, appearing on behalf of Caye International Bank Ltd, the appellant. Mr. Knox KC sends his apologies for not being able to appear this morning.
May it please Your Honors, Priscilla Banner, appearing for the respondent in this matter.
Yes, thank you. In this case, the judgment of the court will be delivered by Justice Burgess, who is the author of the judgment that he is about to deliver. Of course, it is done in the form of a summary, which will not be the authoritative text, but the authoritative text will be the judgment itself. So I pass over to Justice Burgess.
Thank you very much, Presiding Judge Witt. You've allowed me to dispense with the caveat, given that you've announced it. This summary is not a judgment of the court. So I will proceed to reading the summary of the judgment of this court. The appellant, Caye International Bank Ltd, is an international bank operating in Belize and providing online fund transfer services to its customers. The respondent, Rosemore International Corporation, a company registered in Panama, was one of Caye Bank's online banking customers and an account holder pursuant to a depository agreement and an indemnity agreement between itself and Caye Bank. Caye Bank offered Rosemore, as it did all its customers, the use of the NetTeller bank management system, a secure online banking portal used to conduct online transactions. Rosemore, like each Caye Bank customer who utilized the online banking service, was given 2 sets of unique credentials to access the online banking portal. The first credential was the NetTeller user ID and password. Rosemore, like each Caye Bank customer, was first given a temporary password, which was then changed by Rosemore upon first logging in. This changed password was known only to Rosemore. The second set of credentials was the cash management ID and password. As with the NetTeller user ID, the cash management password was changed by Rosemore upon first entering the online banking portal using the temporary password provided to it by Caye Bank. Similarly, this new password was known only to Rosemore. Jason Connor was the sole authorized signatory on Rosemore's account and was also the sole beneficial owner of that account. The email address on file for Rosemore and Jason Connor, respectively, were admin@rosemore.com and jconnor1@rosemore.com. Notably, both email addresses use the domain name @rosemore.com. The dispute between Caye Bank and Rosemore, in this case, is over the sum of US $175,000, which Caye Bank transferred on 23rd April 2015 from Rosemore's account into an account located in Canada in the name of Yaron David Walter. Caye Bank claims that at the time when the funds were transferred, it believed that the transfer was on the instruction of Rosemore. In fact, the instruction was an email account compromise, where the fraudster, Walter, had gained access to Rosemore's email and had sent an email message that appeared to be a legitimate request from Rosemore. At the time the funds were transferred, the account history showed only 2 deposits in the total sum of US $229,683.91 between 2011 and 2015, and 1 withdrawal in the sum of US $1,915.76 in 2012. The fraudulent wire transfer transaction was first discovered by Jason Connor when he received a low priority email from Florence Graniel on 23rd April 2015, informing him that he had a new message in his online banking account and providing him with instructions as to how to view the message. Jason Connor was unable to view the message, and on 28th April 2015, promptly informed Caye Bank of this. After several unsuccessful attempts to log on to Rosemore's online banking portal, Jason Connor was locked out. Caye Bank reset the online account, and Jason Connor was finally able to log on in August 2015. Upon logging on, he was alerted to the unlawful transaction, which he immediately brought to the attention of Caye Bank. Mr. Dean Roche, a director of Caye Bank, refused to accept Caye Bank's liability for the transaction, as he was of the opinion that the transaction had been properly processed by Caye Bank. On 30 March 2016, Rosemore initiated proceedings against Caye Bank and Walter. Rosemore claimed damages against Caye Bank for breach by Caye Bank of the express and implied terms of the Depository Agreement, in that Caye Bank had wrongfully and unlawfully and without Rosemore's authorization or consent deducted the sum of $175,000 US from Rosemore's account. In the alternative, Rosemore claimed damages for negligence by Caye Bank, its agents and or servants in wiring Rosemore's funds to Walter. As an alternative claim, Rosemore sought an order directing Walter to return the funds on the basis that Walter had been unjustly enriched and had unlawfully converted the sum of US $175,000 from Rosemore's account. Walter took no steps in the proceedings, and a default judgment was entered against him. Accordingly, the claim continued against Caye Bank. The High Court found that Caye Bank had breached Clause 14 of the Depository Agreement, which provided that Caye Bank would not process requests from third parties. As there was no evidence that Rosemore had authorized the transfer, the High Court concluded that Caye Bank had processed a third-party request contrary to Clause 14. The High Court further held that Caye Bank breached its implied duties to Rosemore to exercise reasonable care and skill. Caye Bank appealed to the Court of Appeal against the whole of the High Court's judgment. The Court of Appeal upheld the High Court's judgment, finding also that Caye Bank breached its Quincy care duty to Rosemore. On 15 February 2022, Caye Bank appealed the decision of the Court of Appeal to this court. In determining the appeal, this court considered 5 main issues, namely 1, whether Caye Bank breached Clause 14 of the Depository Agreement. 2, whether Caye Bank was in breach of its Quincy Care duty to Rosemore. 3, whether Clause 14 excluded Caye Bank's liability for breach of its Quincy Care duty. 4, whether Clause 15 of the Depository Agreement excluded Caye Bank's liability for breach of its Quincy Care duty. And 5, whether the indemnity clause in the indemnity agreement indemnify Caye Bank against liability for breach of its Quincy Care duty. This court reviewed Clause 14 of the Depository Agreement, which provided as follows, and I quote, "Account holder may, upon verification of signature or upon identification satisfactory to bank, authorize wire transfers to and from the account. All outgoing wire transfers must be from accounts on which the account holder is an owner. No third-party requests will be processed," unquote. In construing this clause, the court adopted the modern objective and contextual approach to contractual interpretation, the Blairmont approach. The court first noted that Caye Bank's only obligation in processing the transfer request was to check the signature on the wire transfer request with the signature on the signature card. This court considered the evidence in the courts below that the secondary verification officer employed with Caye Bank, 1, checked that the wire transfer request contained Rosemore's account number and indemnity password. 2, cross-checked the signature with the signature card on file for Rosemore and the passport of Jason Connor. And 3, noted that the primary verification officer wrote on the wire transfer request that the client called to claim the wire and indemnity password before authorizing the transfer. Based on this, this court found that there was no evidence that Caye Bank did not properly follow the verification and identification process contemplated by Clause 14. Given that the request was received by Rosemore's online banking account and contained Rosemore's secret identification details, it was not unreasonable for Caye Bank to assume that the request was Rosemore's. Despite this finding on this issue, the court held that Caye Bank was nevertheless subject to the Quincy Care duty as outlined in Barclays Bank and Quincy Care Limited. This Quincy Care duty consists of a negative duty to refrain from executing the customer's order if the bank is put on inquiry that its customer may be subject to fraud, and a positive duty to do something more than simply not to comply with a payment instruction. This court found that Caye Bank was put on inquiry as to whether Rosemore was being defrauded, as there were a number of red flags, namely, 1, the substantial amount requested to be transferred was suspicious, given that the history of the account showed that there had been only one insubstantial withdrawal in the amount of US $1,915.76 in 2012. 2, the fact that Rosemore had never made payment to Walter before. 3, the fact that the withdrawal was for the purchase of a property, which was not in line with Rosemore's stated purpose, namely computer programming, management, consulting services to a couple of companies in the UK and prospectively to a new venture in Mexico. 4, the fact that the request came from Jason Rosemore at Gmail, which was not the domain address on record for Rosemore. And 5, the fact that there were observable differences between the signature on the wire transfer request form and Jason Connor's signature. The court found that given the red flags, a senior official from the bank ought to have contacted Jason Connor to verify the transaction. This was not done. The court therefore held that Caye Bank breached its Quincy care duty to Rosemore. Counsel for Caye Bank submitted that clause 14 excluded Quincy care obligation that the bank might otherwise be under. In assessing whether clause 14 excluded the Quincy care duty, the court applied both the traditional and Blairmont approach to the interpretation of that clause. The traditional approach required that an explicit reference to negligence in the wording of the clause in order to exclude negligence, in order that negligence be excluded. The Blairmont approach required that the court consider whether a reasonable outside observer would think that Rosemore was likely to have agreed to giving up its valuable Quincy care right, except by clear words in clause 14 to that effect. Applying the traditional approach, the court found that clause 14 did not expressly exclude the Quincy care duty. And applying the Blairmont approach, the court was of the opinion that a reasonable observer would not believe that Rosemore agreed to give up its valuable Quincy care right without clear words to that effect, as it would be contrary to business common sense. Accordingly, the court concluded that clause 14 did not exclude the Quincy care duty. Next, the court reviewed clause 51 of the Depository Agreement, which stated, and I quote, "The bank shall not be liable to account holder for any action taken or not taken by it under the terms of this document, unless directly caused by the bank's gross negligence or willful misconduct." Under clause 14, it could not be interpreted as being applicable to the implied Quincy care duty. Clear words were required to exclude an implied right, such as that conferred on the customer by this duty, which only arises if a bank is put on inquiry and which is of considerable value to the customer. As clause 51 did not include include clear words to this effect, the Quincy care duty was not excluded. In relation to the indemnity clause, the court applied a similar interpretational approach. The court found that as the indemnity clause did not expressly indemnify the bank for breach of the Quincy care duty, it must therefore be interpreted as not indemnifying against such a liability. This court therefore dismissed the bank's appeal, confirmed the order of the Court of Appeal, and ordered that the bank pay the costs of the appeal to Rosemore. Thank you, Mr. President.
Thank you very much, Justice Burgess, for this perhaps not very summary, but a clear statement of the judgment of the court. Are there any remarks to be made by counsel?
Not on our part, Your Honors.
No, Your Honors.
Okay, thank you very much. Then I will ask the acting registrar to conclude this proceeding.
Thank you, Mr. Justice Witt. Thank you, Mr. Justice Anderson. Thank you, Madam Justice Roger-Lee. Thank you, Mr. Justice Barrow. And thank you, Mr. Justice Burgess. Thank you, counsel. And thank you to the staff of the Caribbean Court of Justice. This court now stands adjourned. Good day to all. Thank you.